The Tung Chung, partner at CNC Council. Joining us from Singapore is Mr. Kelvin Or, partner at CMS Singapore. We are also delighted to have Mr. Na Yoon Kyun, director at FTI Consulting. And last but certainly not least, Mr. Saga Kunthani, founder advocate at Ledwith and a VTA listed arbitrator. Without further ado, we are now going to launch part one of the webinar with the first topic, navigating payment challenge in FedEx project across Vietnam, presented by Mr. Tung Trần. About Mr. Tung Trần, he is a partner at CNC with more than 10 years of legal practice experience in construction and real estate. Before joining CNC, Mr. Tung practiced as an in-house lawyer at Novaland Group, one of the leading real estate investors in Vietnam, and as an in-house lawyer at Hòa Bình Construction Group, one of the largest construction contractors in Vietnam. The working experience gives Mr. Tung a deep understanding of real estate and construction market, both in terms of legal aspect and market practice. In addition, Tung had many years of experience in drafting, negotiating, and managing FedEx contracts for large-scale construction projects and regularly participating in sharing knowledge and experience of FedEx contract to practitioners in Vietnam. Alongside CNC dispute resolution team, Mr. Tung has participated in numerous high-value and complex international arbitration cases at VIAC, SIAC, ICC, and other institutions. Mr. Tung had co-authored the chapter FedEx application in Vietnam in the Construction Law International magazine of the International Bar Association, or IBA. He also a member of the Society of Construction Law Vietnam, or SCLVN. Besides construction and real estate, Mr. Tung had also consulted in issues related to international sale of goods, renewable energy, hotel management agreement, and project finance transaction.
Thank you so much, Trang. Trang, can you how to close your share screen? Can everyone see my screen? Can everyone see my screen now? I think it's good, right?
Yeah.
Okay. Thank you so much for everyone for joining us today. Now we have a turn to talking about the payment risk in construction contract across Vietnam. For my presentation, I will talk about the navigating payment challenge in FedEx-based project across Vietnam. In my presentation, I will have a three part. The first one, I will talk about some differences between the FedEx and Vietnamese law in relation to the payment term. And in second part, I will talk about the taking over certificate and payment risk. And the last one, I will talk about some notes for price adjustment. For the first part is the payment term difference between the FedEx contract and Vietnamese law. And the reason why I would like to address this issue, because if you work for the private fund project in Vietnam, it's absolutely no problem if you fully adopt the payment term and FedEx contract in your project. But if you work for state fund project in Vietnam, it may be the huge problem because you cannot fully adopt the FIDIC payment term into your contract. You need to follow some standard provision based on the Vietnamese law. If the party not comply with that law, the project will face with some significant risk, such as the project may be suspended by the state inspector because they see that the party not comply with the law. So what kind of difference we have here? The first one is about the repayment of advance payment under the FIDIC contract 2017. The repayment just starts from when the accumulated value of certified APC is at 10% of accepted contract amount. But under the Vietnamese law, the repayment shall commence promptly from the first IPC after the advance payment. And in both FIDIC contract and Vietnamese law, the party need to agree about the percentage of repayment in your contract. But in the absence of such agreement, the FIDIC contract will automatically apply 25% of its IPC. We have no such kind of provision under the Vietnamese law. And under the FIDIC contract, the advance payment must be fully repaid prior the issuance of TOC or in the event of early termination of the contract. But under Vietnamese law, the time comes sooner. The advance payment must be fully repaid when the payment amount reaches 80% of original contract price. The next one is about the periodic payment, or we usually call it the monthly payment. Under the FIDIC contract, it's a payment made for the executed work. It's not for completed work. It means that the contractor do not need to submit minutes of acceptance in the payment document. But in contrary, in Vietnam, the payment is made for the completed work. It means that the contractor need to submit the minutes of acceptance. And understand that we have a lot of engineers in this room today, and it's absolutely different between executed work and completed work in construction. The next point is about the payment periods. Under FIDIC contract, we have a 56-day period from the day the contractor submits statement together with supporting document to the engineer. In the Vietnamese law, we have a 14 working day, but it calculates from the day the employer receives full and valid payment document from the contractor. Under FIDIC contract, the engineer shall be obligated to issue the IPC, regardless whether the payment document of the contractor is fully valid or not. It means that it's no case that the engineer can return the payment document to the contractor to ratify. It's not allowed to do that under FIDIC contract. But in Vietnam, if the payment document is not fully valid, the employer can return them to the contractor for ratifying before the contractor can submit again. The next point about the final payment, or we can call it the final statement in the FIDIC contract. In the FIDIC contract, the final payment will make after the expiration of DNP and the PC has been issued. But in the Vietnamese law, the final payment will make after TOC. But for the state fund project, the final payment should only be made after the final inspection by the competent authority for putting the work into operation. It means that the early completed package must wait. For example, in the whole project, we have a lot of packages, and some packages complete early and some packages finish later, like finishing work or something is finished later. But the final inspection procedure, it applies for whole the work when whole the work completed. It means that the early package cannot make the final payment first. It also need to wait when whole the project is completed. The next point is in the FIDIC contract. It allows the party to agree partial final payment. It means in the final payment, some items the party agree and some items still have a dispute. The party can agree the partial final payment. But under the Vietnamese law, we do not allow to do that. We require the party to agree the final payment for all the items. The next point is under FIDIC contract. The additional cost for remedying defect during the DNP due to no fault of the contractor shall be treated as the VO and shall be included in the final statement because final statement is made after the DNP. But under the Vietnamese law, because the final payment already made after TOC, it means that any additional cost during the DNP need to be separated into the new contract. The next point is the retention money, or in Vietnam, we usually call it the warranty amount. Under FIDIC contract, it's will based on accepted contract amount, but under the Vietnamese law or practice, it needs to base on the final contract price. It's different. And the next point is, I think it's interesting point, is the question, can the payment could be released after time for collection? And under FIDIC contract, I see that no one will ask this question because the answer is absolutely yes. It's no reason to hold the payment up to the time completion because it's a absolutely different problem. But under the Vietnamese law for state fund project, the employer likely impossible to make payment after time for completion. And for the foreign party, it's made difficult for them to understand the reason behind. But from the viewpoint of the authority, the time for completion of the project is fixed and approved by the high authority from the outset of the project. And it's required the party, including the employer and the contractor, to strictly comply with that time for completion. And if you do anything after the time for completion, the question is who allow you to extend the time for completion? And if nobody allow you to do that, no high authority allow you to extend the time for completion, it's likely that the work done after time for completion is not legitimate for payment. And in that case, the employer and the contractor need to find a solution. They need to submit the extension of time to higher authority to get approval. And then the party need to sign the contract addendum to extend the time for completion. And after that, the payment only can make after that. And the next point is evaluation and payment of VO. Under FIDIC contract, the VO shall be evaluated after execution. It means that the contractor needs to execute promptly, and then VO evaluation come after. But under the Vietnamese law, the evaluation of VO must be agreed in advance before execution. And in FIDIC contract, we do not need the contract addendum for payment of VO, but under Vietnamese law, the party need to sign the contract addendum to the basis to make payment for VO. And the last point is the EUT cost or all the kind of claim costs. In FIDIC contract, we have a concept of pay now, argue later. It means that the claim cost will be determined by the engineer and then the DAB decision before final result by arbitration. And the determination of engineer and the DAB decision is binding the party, but not final. It's binding means the party need to comply and then they have a chance to argue later in arbitration. But in Vietnam, we do not have a such concept. It means that all the dispute need to be resolved by arbitration or court, and it may take several years for hold the dispute resolution. The second part of my presentation is about TOC and the payment risk. And the question is why TOC matter for the payment risk. I can list here at least 4 reasons why TOC matter for payment risk. The first one is the TOC trigger the right to subsequent payment for the contractor, including statement of completion and the first half of retention money. And the second is the TOC sees the validity of performance bond because under Vietnam practice, the party usually agree that the performance bond will valid until TOC, but not PC like FIDIC contract. And the third reason is the TOC will trigger the right to submit the warranty bond to receive second half of the retention money. And the last point is the TOC will determine whether the contractor will be liable for delay damage or not. The practical issue in relation to TOC in Vietnam is that under the Vietnamese law, the issuance of TOC is prerequisite for final inspection or approval by the Ministry of Construction or Department of Construction to put the project into operation. The concept here is that the employer must check and accept the work before they invite the authority to double check again. But in the practice, the employer do not want to take the risk that the TOC has been issued, but later that the MOC or DOC refused to grant approval for the project due to some remaining outstanding work or some defects not remedied. But in that case, the contractor can say that, hey, the TOC has been issued. It means that my work already completed and hand over to the employer. To deal with that problem, the employer may follow the way that the temporary TOC will be issued to satisfy the condition for inviting MOC or DOC to conduct the final inspection. And the actual TOC will only be issued when MOC has granted the approval for the project. But the legal question here is that whether the contractor can rely on the temporary TOC to consider the work as completed and hand over, or whether the employer can deny the validity of such temporary TOC. To answer this question, we have a decision number 3 of 2024 of Supreme Court. In that case, the contractor was still carrying out the remaining work as recorded inside diary and relevant document, and to support the fire prevention and fighting procedure, the contractor suggested that the employer grant TOC, and the employer accepted that suggestion, and in the minute of submitting, both parties agreed that the TOC will not serve as the evidence of completion of the work. But when the dispute arose, the contractor asserted that the work had been completed based on the TOC. And the ruling by Supreme Court is that the court rejected the contractor position. The court ruled that the issue of TOC was not valid for the purpose of certifying completion of the work. By doing so, the court not rely on the contract term, but also relevant document to ascertain due purpose of TOC. The last part of my presentation is the prior adjustment, what should be noted. Under the Vietnamese law, or especially Circular number 2 of 2023 of Ministry of Construction, we have two methods for price adjustment. The first one is PN methods. PN methods in there is a lot. The concept is aligned with the concept under FIDIC 1999. And the second method is direct compensation method. And now we will talk about the PN methods. And as you may know that under the PN methods, the key element to apply this method is the available of the price index. But the practical issue is that the sort of price index should be based on the information provided by the competent authority, usually that the Ministry of Construction or Department of Construction. But the problem is the price index only available for very typical construction work. For example, housing work or hospital or the factory or road work. For special project like metro project or airport or power plant, it's likely that no official price index is available for the party to apply. In that case, the employer must engage the eligible consultant to establish the new price index and submit it to MOC or DOC for verification. But the problem here is that the price index establishment process is very complicated and time-consuming due to several uncertainties, and we have a lot of questions need to answer. The first one is who can be considered as eligible consultant for this work. And when we have eligible consultant, the next question is that whether the consultant has sufficient and reliable information to establish the new price index. For example, like major project in Vietnam, we do not have a lot of major projects. So how the consultant can collect the reliable information to establish the price index for major project in Vietnam? Or can the consultant collect the information in China market or Singapore markets? The answer is likely maybe no, because it's very different market with different circumstances. And the next question is how long it takes for the authority to verify the new price index? And they will base on with benchmark. Because if the authority not rely on the appropriate benchmark, the result is will not comparable. It's not appropriate for the party to apply. And the next question may be whether the established price index can be applied retroactively. For example, if it takes 1 year for the consultant to establish the new price index and the authority to accept that price index, can the contractor apply that price index for the work done in the last year, or can the contractor only can apply for the upcoming work? Yeah, That is the question need to be addressed. And the next question is that what the contractor can do if the price that's established by the consultant is not appropriate. For example, can the contractor hire another consultant to establish the new price index, or can the consultant challenge the price index established by the consultant, or can the contractor comment or provide the additional information to the consultant? Because in that case, the consultant is employed by the employer. And the next question may be, what is the solution the party can adopt to maintain the contractor cash flow? Because if it is the case that the price adjustment project takes 2 or 3 years to finish, and during that time, the market price increased significantly, it skyrockets. So it's not be the case that the contractor will accept to use the same unit price from the outset during that 2 or 3 years. So we need to think about the solution to maintain the contractor cash flow. To finish my presentation, I like to quote the very famous sentence from Benjamin Franklin. He said that by failing to repair, you are preparing to fail. And I think that the same concept could apply for payment risk mitigation. The being fully aware of the anticipated risk from the outset of the project could help the party prepare appropriate contract provision and mitigation plans. It's the end of my presentation. Thank you so much. And if you have any question, I'm happy to answer in Q&A session. Thank you so much. And back to the MC.
Thank you, Mr. Tùng. The next topic, payment strategy with Byte Singapore perspective would be introduced to us by Mr. Kelvin now. A few words about Mr. Kelvin. He a partner at CMS Singapore and a co-host of the infrastructure and construction practice. With nearly 3 decades experience in the construction, engineering, and infrastructure sector, he advised on major projects across Asia and the Middle East, and regularly, I'm sorry. And regularly represent clients in high-stake dispute before Singapore courts and in international arbitration like ICC, SIAC, AIAC, and CIETAC. He also a senior accredited specialist in building and construction with the Singapore Academy of Law and accredited senior adjudicator with the Singapore Mediation Center, recognized by Chamber Legal 500 and Penmark litigation for his pragmatic and commercial approach. Kevin is also frequent speaker at industry conference.
Good afternoon, everyone. I think you can see the screen. If not, raise your hand. Thank you for the introduction. I'm going to be sharing a perspective from Singapore. This is obviously not Vietnamese law, but we have been following the Vietnamese construction industry and practices for some years. And I think there is some learnings between Singapore and Vietnam that we can contribute. As much as Singapore is learning also from Vietnam in ways of DAB adoption, there's also some lessons that Singapore can also share with Vietnam. So my focus of my talks will be on that. Just a word about myself. I am a partner in the Singapore office of CMS. CMS is the 5th largest law firm in the world. Although our presence in Asia is limited to Singapore, China, and Hong Kong, we work in Vietnam with firms like CNC Council, so as to establish a greater and more effective Vietnamese presence. So in summary, I wanted to just trace back about 45 years of construction issues relating to payment in Singapore. And that starts pre-1980. And then there was an enactment of a contract form called the SIA Conditions that was enacted in 1980. A note that this is not law, but this is a contract standard form that is adopted by the private sector in Singapore. And how the creation of this concept of temporary finality of certification for payments has become a practice that's pervaded over the Singapore industry. However, there were issues relating to the adoption of the SIA conditions, which then necessitated the enactment of the Security of Payment Act in Singapore. This is an act that we enacted in 2005. We borrowed concepts from Australia, from the UK, and from New Zealand, and we came up with a very similar act that is in these jurisdictions. After Singapore enacted the Security of Payment Act, Malaysia also created their own called the CIPAA or CIPA. And just recently, 28th of August, Hong Kong also enacted their own Security of Payment Ordinance. And I understand, within the civil law jurisdictions in Southeast Asia, Thailand is the next one to go. We have seen the bill issued from the Thailand Parliament, but it has not been enacted as law yet, but it's something that is worth watching and something that perhaps the Vietnamese authorities might want to consider when you revamp your construction law. Now, I just want to set a scene in 1980 and before. The creation of the Singapore Institute of Architects form is actually quite phenomenal. It was drafted by a Queen's Counsel called Sir Duncan Wallace, who has passed on a couple of years back. And he studied the landscape and the construction industry in Singapore, and he saw there were a lot of issues that was presented by Tong just now. Even though there were concepts of certification for payment, a lot of employers either under-certify, do not certify, or even after certification, they refuse to pay, or they pay partially, or they delay payment. And that has a critical impact on the construction industry, particularly for contractors, and then downstream subcontractors. And that led to a lot of insolvency, bankruptcy amongst the contractors in the market. And that is not good because in the 1980s, Singapore was trying to build up its infrastructure, and we needed a lot of help and assistance to the contractors in the market. So what was created in this contract form was a concept of temporary finality. And this concept has actually found its way into the FIDIC Form 1999 and also found its way into the latest FIDIC Form 2017. So the concept is very simple. A payment claim is made, and once a payment claim is made, the architect must certify payment. It can certify less, it can certify as claimed, but whatever is certified, it has to be respected. So pay now, argue later. And that is not just what the contract form went for. In addition, it looked into the Singapore court machinery and the arbitration machinery. And there's a machinery called the summary judgment concept or an interim award concept in arbitration. Now, this is a concept where there is no entitlement to raise a defense against a certificate. So even though an employer might have a set of a defense in respect of defective work, or they're just generally unhappy, they cannot raise it. So what the contract form has to force both parties to agree that whatever the architect has certified, it has to be respected, not just between the parties, but also before the court of law by way of summary judgment. And if parties do want to go to arbitration, then it has to be recorded as an interim award. So essentially, payment security in Sir Duncan Wallace's concept was basically two folds. One, the contract rights to payment is created by the contract. And it has teeth. It is not just a contract term. It has teeth in the courts and arbitration for enforcement. So the contractor who has not been receiving payment based on the architect certification can quickly run to the courts, and within 3 months, he can get a judgment against the employer. Likewise, a subcontractor can also deploy the same machinery against the contractor. And that has found a lot of success in Singapore from the early days from 1980 all the way to the 2000s. But unfortunately, the Singapore Institute of Architects form is just one of many forms. There are other forms that were emerging in the market. There was the REDAS form, there was the public sector form, and all these forms, to a certain extent, does provide, but also to a certain extent doesn't quite address the payment security with teeth. So what these forms, however, created was additional rights that could be deployed by the contractors to secure payment early. For instance, if there should be late payment, then there is an interest obligation payable by the employer, or there can be a right of suspension that can be deployed by the contractor, or in a very serious case, it can lead to termination by the contractor. So this has contractual teeth. Second, security deposits can be replaced by performance bonds and banker's guarantee. I think that's quite common in the market now. But in the 1980s and before, security deposits were in fact security deposit, which is cash, and no bonds were acceptable. Third, retention monies. The government of Singapore has decided that it will no longer retain retentions or warranty monies, as you understand it in Vietnam, under public sector contracts. So this has alleviated quite a bit of cash flow issues amongst contractors. And fourth, the use of retention bond to replace retention monies. And this has been adopted in the FIDIC Form 1999, where contractors can obtain a release of retention monies early by giving a retention bond, which is really just a bank guarantee for the amount of retained monies. And then finally, there is this concept of contractual adjudication or mediation. These are also found in the FIDIC Form 1999 as well as 2017. These are essentially dispute adjudication or dispute adjudication board machineries that can, in certain sense, help to alleviate the cash flow problems. But we understand that all these are just contractual mechanisms. It really requires the good faith of both parties to abide by these conditions. And in the event that the employer or the main contractor refuses to pay despite these mechanisms, then there is no teeth to activate these obligations. And which is why in 2005, there was a study done in Singapore to create a machinery where it becomes a statutory obligation. So not just a contractual obligation, not just a court obligation, or not just an arbitration obligation. It becomes a legislative obligation, which means that all construction contracts that is being activated or carried out in Singapore, and sometimes other parts of Singapore, will attract the creation of the Security of Payment Act, attract the activation of the Security of Payment Act. So this is a machinery that creates legislative force, and it was introduced in 2005. When we started this legislation, there were only a handful of cases in the first year. But up to 2024, for a small country like Singapore, we have in fact gone through about 4,773 adjudication applications under the Act administered, and it has facilitated payments, particularly for subcontractors, of over 940 million Singapore dollars. These are small amounts compared to what you are familiar with in Vietnam, but if you if you appreciate the size of Singapore as being small, these amounts are actually quite significant. So features of the Security of Payment Act are as follows. It applies to all construction contracts, all supply contracts, all engineering and architectural contracts, even fit-out contracts. As long as it's not related to home renovation works, which are minor works, the Act will apply. Number two, there is a prohibition of pay when paid. So essentially, a contractor who is owing monies to a subcontractor can no longer tell the subcontractor that I have not received payment from the employer, so I cannot pay you. So that sort of defense is out of the window. It's deemed illegal under Singapore law. Number three, there is a strict timeline as to the rights of progress payments. So the contractor has to pay a subcontractor within X number of days. and this regime will override contractual timelines. And number 4, if there is no resolution as to the payment dispute, then there is a machinery under adjudication that can be deployed by the contractors and subcontractors or contractors against the employers. This is a low-cost, quick methodology of dispute resolution that is far faster than the arbitration and even faster than mediation, one would say. So a quick timeline of the Security of Payment Act shows that from the time a contractor puts in a claim up to the determination of the case, it takes about 2 months maximum. And of course, there are instances where parties can agree to extend time. But if one party decides not to extend time, then the 2-month period will stay. So this forces employers or main contractors to issue out cash flow in a timely manner without having to deal with issues of defects, defenses, set-offs, or unhappiness over valuation or variations. So all these are put in the bandwagon and pushed to arbitration later on, but payment must be made. So as what Tom said, pay now and argue later within 2 months. Further features of the SOPA relates to the handicap of the respondent. So this is one feature that is a bit disturbing to lawyers. Essentially, if the respondent does not issue a payment response or it doesn't provide reasons to a particular claim of a contractor, then he loses the right to defend himself. So he's only given one chance to defend himself on writing. And if he doesn't issue that payment response in writing, he cannot raise it later on in adjudication. So in that sense, a claimant, like a subcontractor, is able to entirely get a determination without any defenses. So that enhances the features, the capability of claimants in getting a good outcome. And once the claimant obtains a determination, there are 4 things that he can do. He can activate a direct payment provision from the employer, if the employer wishes to do so. Number 2, he can exercise a lien or a right over unfixed goods. So for example, goods that are delivered onto site but are not installed onto the building yet, those can be recovered and moved back to the subcontractors' warehouses. So he can take it back. Number 3, he can suspend works. Otherwise, under Singapore law, there is no right of suspension just for payment. But the Act says now that you can suspend work as long as you have a determination in your favor. And the 4th, which is the most important, you can convert the determination to a court judgment. And you can, in fact, go after the main contractor or the employer, including bankruptcy, just to get the payment out. So these are very draconian measures, but it's essential to deal with an industry that is steep in dispute issues, payment dispute issues. So there you have it. In a Venn diagram, there are the interaction of 3 bases for payment security. 1, contractual rights. Number 2, not just contractual rights, but court or arbitration enforcement. And the 3rd, we have set up a statutory baseline to watch over these 2. So whatever is stated in the contract cannot exceed the statutory baseline. And whatever the courts and arbitrator has to say also cannot exceed the statutory baseline under the SOPA. So that's all I have to share. Happy to take questions at the Q&A. Thank you very much for your time.
Thank you, Mr. Kevin, for sharing your valuable insight. Before I introduce our next speaker, I would like to invite all attendees to share your questions in the Q&A box, and our speaker will address them during the discussion session. For the third topic, of Part 1, Mr. Na Yoon Kun would tell us about payment risk for foreign contractors in Vietnam. About Mr. Na, he a civil engineer, quantity surveyor, and director at FTI. He specialized in cost and commercial management, contract administration, and quantum advice. Mr. Na Yun Kun had extensive experience having worked throughout Asia, including Vietnam and Singapore, in various commercial management and project control roles. That experience include advising and managing multiple formal disputes, including adjudication, arbitration, and litigation. Mr. Na Yun Kun had 19 years industry experience in commercial procurement, planning, contracts, and dispute management of project size, as well as managing variation order and extension of time claim at individual site levels and at corporate level of a Tier 1 international general construction contractor. Mr. Na Yun Kun is a Korean professional with extensive experience throughout Asia and the Middle East, having worked in various commercial management and project control roles. His expertise including advising and management and managing multiple formal disputes, such as adjudication, arbitration, and litigation. As a native Korean, Mr. Na Yun Kun offers a unique advantage to Korean clients by providing expert service in their monitoring, ensuring seamless communication and cultural understanding. Now the stage is yours, Mr. Na Yun Kun.
Thank you for the introduction, Ms. Chang. Let me share my slides. Good afternoon, everyone. As we introduced, I am YK Ra. I will be sharing my views on what I think are the payment issues that foreign contractors are facing here in Vietnam. I understand I am the only non-lawyer among the panelists, and as you will appreciate, I have some rather painful first-hand experience of going through the payment issues as a foreign contractor in Vietnam myself. So I am excited to share my first-hand views, and I hope that you will agree with me on some of the solutions that I propose. I will briefly introduce about myself. I will set the scene as to why I chose this topic. And then I will briefly share the key payment processes and the common problems that could happen in any one of those processes. Followed by, I will look to identify what are the underlying causes causing so many problems. And I will conclude by sharing my views on what will be the best practice and recommendations in resolving payment disputes. As introduced, I am a building engineer, and I am also a chartered quantity surveyor. And I am a member of the CIR, and I've had 16 years experience at a top-tier international contractor. And combined 3 years of that experience, I spent in Vietnam, being involved in rather some of the famous projects in Vietnam, as you may recognize from the picture to the right side on my screen. And for the last 3 years, I was at FTI, advising clients in construction disputes. Foreign contractors in Vietnam, I think the general consensus nowadays is they are not as active as before, primarily because of the emergence of local contractors such as Hoa Binh, Cotecon. I think they can build almost everything nowadays. But still, foreign contractors are around. Some ODA agreements may require foreign contractors, and also some special buildings, power plants, oil and gas, I think is still predominantly being built by foreign contractors. But they are facing the same old challenges: payment disputes, project delays, and uncertainty in dispute resolution. So they all culminate to become one single problem of payment dispute. This is what I wrote down as a typical payment process. First of all, physical work will have to be completed, and inspection and quality check process will follow. And then payment app will be applied and assessment, then the payment. And as most of the practitioners in this webinar will agree that so many things can go wrong in each of these steps, and I will look at them with you one by one. Physical work. Even before a contractor can commence physical work, they have to obtain subcontractor and supplier approval. Material, input material that goes into the construction have to have the inspection. And also, needless to say, method statement and shop drawing also needs to be approved previously. Some of these may be both legal and contractual requirement that contractor must be aware when carrying out the physical works. Then, after the physical work is completed, then comes the inspection and the QC procedure. Contractor will send in the RFI, otherwise known as request for inspection. Then there could be delays in inspection, or delays are the more commonly made by the contractors themselves. Contractors will be always very aggressive. Oh, we'll definitely cast the concrete tonight, but it doesn't happen. Then the resident site staffs do not stand by and they go home late at night. So the pre-arrangement must be in place to ensure that the contractor promises to pay the overtime wages of the resident site staff so that they remain until the concreting is finished. Even after such a QC document, the completion documents are completed, then comes the work acceptance minutes. The work acceptance minutes could be prepared by the contractor and submitted well in advance to the PMU, but it could be sitting in PMU director's desk forever, and he may not want to sign for whatever reason. And some of the reasons I will discuss later in my slides. So after all that, then contractor will be consolidating all the QC documents, all the legal documents, and put it into a nice payment application. Not much could go wrong here, I hope. Then comes the assessment phase. And I think this is where many things could go very wrong. There could be disputes over the quantity. And I think more importantly, there will be disputes about whether the employer and the contractor agree on whether it's a variation or not. I think this is particularly important because if it is not recognized as a variation, then definitely the PMU director will not sign on the work acceptance minute. That means the contractor will not be paid for all or part of the works that he performed under the variation. So the contractor will be affected with cash flow issues. Extension of time, whether extension of time is accepted or not, the contractor will still submit the prolongation cost claim together with his interim payment application. And it's the same issue. If it's not recognized, then the PMU director will not sign on the work acceptance minute. There could be further disputes in legal and QC documents. So the one thing that I experienced is, I will cover later in the slides, but especially for a foreign contractor, what is written in the Vietnamese law and what is also written in the contract for documentation requiring for payment may be very different from what they as a foreign contractor understand and what is actually required. Lastly, payment. Of course, so many things can go wrong at this stage as well. The owner may not pay, or they could delay the payment, or even pay partially. The most standard forms of contract will have ways of dealing with these issues and may give a contractor rights to suspend or have rights to claim for delay interest. These 3 points are what I think are the underlying causes of causing these so many problems. The first one, I think it's down to the regulatory or legal interpretation and disputes in valuation or assessment. And lastly, I think to some extent, some difference in contract administration also has a part to play in causing payment disputes. First, for the regulatory or legal interpretation, this is an extract from the relevant law and decree of what I think are most relevant to the payment disputes. The construction law and the Decree 37, I think they stress the importance that the work must be actual work completed and the work accepted documents has to be in place. And also that must be combined with what is mentioned in the Ministry of MOC's Circular number 26, that it must be accompanied by a daily site diary. So I think the foreign contractors who are operating in Vietnam for the first time may struggle to get a good concept of what these are, because they may not be very clearly stated in the contract. And also the law stops right there. So domestic Vietnamese contractors will have perfect understanding of what is inherently required sitting behind these words. But foreign contractors, if they are not clearly spelled out in the payment terms in the contract, then they may not know what exact documents that they have to prepare. Disputed valuation or assessment. I think this is one of the most common problems that cause payment issues. So for variation, I think if the parties can at least agree that it is a variation, then they can consider adopting like a tentative variation. I am minded to what Mr. Tung said earlier, that the Vietnamese law does not necessarily accept partial payment or interim payment, but still, if they can somehow agree between the parties that they will at least acknowledge that this is a variation, then the PMU director can, based on that agreement, choose to sign and assess a part or all of that variation work so that the cash flow can be moving. For disputes on quantity and rate, I have faced some real experience where the quantity that I, as a QS, knew to measure and how the Vietnamese, some Vietnamese measures differently. So I think to make this clear, I think if we could mention this in the preamble, or even better, specify which version of SMM or standard method of measurement to be used for the project, then that will reduce the certain disputes in this respect. Rates, I think it's more tricky. Where there are star rates, then it is no issue. But usually when there are no star rates, then the contractor is expected to come up with 3 quotations at least to prove that they are using the most competitive rate. But usual cases, they happen urgently. So what happens is there will be subcontractors already mobilized on site. Then the contractor will instruct one of them to give a quotation, and so that they can just readily get on with the works very quickly. So it is very difficult to justify that price that one single contractor submits. So what I usually do is I break it down to labor, material, and equipment, so that I give some credible evidence to the employer that this is not just random rates. When I checked against these, when I break it down, these are reasonable. Then based on that, the employer also can have more certainty when he's obtaining his approval of his chain of command. So that's also another solution that I propose. If for other disputes, then obviously they will have to go into dispute resolution processes specified in each of the contracts. And I will briefly share my experience in DAB at the conclusion. Contract administration. Why I have this here is because I think I have a very unique experience of administering a collaborative form of contract in Vietnam. In a cost plus fee measure, I made a contract based on the NEC 3, and it was a cost plus fee contract. Why do you think certain owners will adopt a cost plus fee type of contract? Probably because design is not ready yet. And because design is not ready, the contractor or the owner cannot have certainty on how much it will cost to build such a project. And plus, some developers may not be big or sophisticated as a big Vingroup or Novaland Group. They may be very small and up and coming, so they want to rely more heavily on the expertise of the cost plus fee contractor. So that's why they may choose this procurement method. But again, so many things can go wrong here, because if it's a cost plus fee, there's a very inherent conflict of interest, because greater the fee, then the greater the fee, greater the cost, then the greater the fee of the contractor. So the contractor has no motive to make the cost lower. So it becomes particular problem when tendering for subcontractors. Obviously the owner want to procure the subcontractor at the lowest possible competitive rate, but contractor simply has no motive to do that. They want to perhaps use the best qualified contractor. So that difference in conflict of interest delays the procurement steps. And also, cost plus fee, the most challenging part is, I think, defining the allowed and disallowed cost. For example, if I were to have a lunch downstairs and have a banh mi and pho,
I
is
lost
there
you.
an allowable cost or disallowed cost?
Good, I lost you.
So to avoid that, what I did was, at least for the indirect cost, then I made an agreement with the owner that per head, how much per month, so that we don't have to go through the process of looking for the receipts. So this comes down to my summary. First, I think structuring a very clear payment clauses, clearly specifying what are the required documents is very important. And second, the contractor and subcontractors also have to play their part. They cannot just simply cry that, oh, owner is not paying. They have to do their part in properly documenting the payment application. And lastly, if all fails, dispute resolution. And I understand that DAB is gaining some traction in Vietnam, and FTI has a very pleasant experience of successfully helping the client get an award, and both the owner and the contractor of the project complied with the award, and they got paid. And we received a very heartfelt thank you email from the client. So I think the DAB is getting traction and will be a good, effective way and cost-effective way to resolve disputes. This is the end of my presentation. Thank you, and I will take questions later.
Thank you, Mr. Na, for your practical perspective. Please note that we are still welcoming your query, audience. Our last topic of Part 1, resolving payment dispute under an arbitrator perspective by Mr. Saga Kulkarni. About Mr. Saga, he is a seasoned legal professional with over 14 years of experience in cross-border regulatory compliance and corporate investigation, mediation, and international dispute resolution. His advised global business across sectors, including construction, energy, infrastructure, IT, renewable energy, and emerging technology, with expertise in commercial law. My bad again. With expertise in commercial law, finance, digital trade, and cross-border agreement, he supports clients in dispute resolution, arbitration, mediation, and settlement negotiation. He also guides companies on regulatory compliance and strategy decision-making in complex international transactions. Now I would like to hand the floor over to you, Mr. Saga.
Thank you very much, Mr. Trang. It's an honor to be on this webinar with the expert panelists that CNC and VTA has brought on board. And I would like to express my gratitude and compliments to VTA for, allowing me to be their mascot in this webinar and uh, giving me this opportunity to participate in this webinar as their arbitrator. And I can definitely say that, let me just start by sharing my screen as well. Okay. Okay. So a bit about myself. I am based out of India, and as far as my practice is concerned, like Ms. Strung already explained about the areas and sectors that I practice in. And a majority of that is, of course, council focused practice. And of course, I also act as an arbitrator in many of the domestic disputes as well as international disputes. And I would like to share a short experience about my practice as well as the cases that I have, faced in my routine practices. And of course, being the last speaker, of course, we are always at a disadvantage because, of course, I might be, interrupting maybe the PPT, of course, going through 4 PPTs is in an hour is something which I understand might be tiring, but I'll try to keep my presentation very brief. And of course, I'll try to, as many of the speakers have already covered majority of the points also, I would like to just briefly highlight and, provide you an insight as to what exactly the arbitrators or the lawyers should try practice or try to develop a practice towards making the disputes more compliant, I would say. So my topics that I have covered in this slide are majorly going to explore what kind of compliances the parties can have and what should be the practices, basically how this compliance also will help the parties in overcoming long or tiring arbitrations. So if you have certain strategy which is in place right at the start of the project, I think it will help you over the period of the project to basically be on the top of your game when, if at all, there is a dispute with the party. So the topics that I would be covering is basically contractual considerations. What kind of compliances can parties have in contractual when they're determining contractual drafting and executing the contracts? Then what are the types of payments? Of course, my fellow panelists have already covered majority of the heads. So I'll briefly touch upon the compliances which might be useful, when deciding on the payments aspects. Then the types of disputes, which are very fairly common in the construction disputes. Then the arbitration process, what could be a more efficient process that the parties can follow just to avoid long and economically draining processes. And of course, I'll try to give some best practices and strategies to avoid disputes. Of course, by saying that, we are eliminating the scope of appointing an arbitrator, appointing the lawyers. But yes, of course, these are strategies which can be utilized by the parties. And of course, these eventually could become a good type of evidence when the parties, eventually get into arbitration. So these are the practices which can showcase a party's uh, intent during the project. So these are all touching on the evidences the parties can try to develop during the execution of the project itself. So it's important that you come before the arbitration with, a focused dispute. So that is where these best practices and of course the dispute avoidance strategies would become very important. Then I'll be sharing a few case examples, both from VTA perspective as well as my own perspective, where I had undergone an SISC arbitration, and will be closing remarks. So to introduce, of course, we all know that cash flow is king, and construction projects live and die on cash flows. So what could be the best compliances that you can follow to have a good cash flow in your projects is something that I'll discuss further. Then the due process, of course, is equal to crown, because efficiency and following professionalism is very important. You need to understand what kind of procedures or what is the fair practice that is beneficial for you as a contractor, for you as an employer, and of course for you as a subcontractor, to maintain your dignity before when you are into a dispute. Then of course efficiency is also a key. So we need to understand the what kind of strategies that would help you in making disputes more efficient is something that could reflect through your contracts itself. So whether you want a mediation, whether you want a multi-tiered arbitration is something that we can discuss once I start going through the slides. Okay, so what are the contractual considerations that the parties should take into, of course, clear arbitration clause? It's very important that you have at the outset a very clean and clear arbitration concept decided before you enter into a project, because you don't want your dispute to be dragged at stage one itself. So this all, whether you want an arbitrator, whether you want 3 arbitrators, whether you want sole arbitrator, what should be the seat in case of a cross-border dispute, what should be the best seat that you can select as a jurisdiction. Of course, for that, you'll need to analyze the court practices in that jurisdiction, the enforcement proceedings, and of course, you will also need to appoint a particular arbitrator from that particular jurisdiction to have a fair analysis of the arbitration. Then what can be the scope of disputes? You can, whether payment disputes have been expressly included in your arbitration clause. The rules, of course, I would always recommend that the parties undergo an institutional arbitration, because you have someone to administrate your disputes rather than an ad hoc arbitration, because in ad hoc arbitrations, the stage one itself gets a lot delayed, because parties tend to appoint their own arbitrators, which might get one party might agree to an arbitrator, the second party might not agree. So there might be disagreements right at the stage of appointing an arbitrators. Then the second aspect would be, of course, having precise payment terms, which my fellow panelists have already covered. And whether you want a lump sum contract, whether the project should be pay as you go, or what should be the penalties and interest for late payments. So these are basic, of course, the basics that I want to cover, and basics. I would like to give you a brief highlight about what the arbitrators see prima facie when the arbitration comes to their plate. So then, were there any precedents, condition, or the payment was conditional payment? So these are all the tests that the parties need to put in their payment terms. And of course, I would always suggest that the parties verify the employer, the main contractor, if they are a subcontractor, of course, and vice versa, of course, whether the funding for the project or the sources for the project are adequate enough to cover their payments, and whether there is certain kind of if in case of cross-border disputes, of course, tracing assets of the employer, subcontractor, contractor, would be beneficial at a later stage, because this will give you a niche above all the stakeholders in the project, to basically make claims of your payment. Then, of course, what are the performance specifications need to be clearly highlighted into your contracts or the tenders. Then, whether you have a clear technical understanding of what exactly is required from your side, and whether they have been clearly drafted in your contract as schedules or exhibits or whatever, and whether the exhibits and the schedules have been clearly highlighted in your clauses of your terms and conditions of your contract. Then, of course, specific references to standards, whether you want it under the FIDIC conditions or other industry benchmarks and technical parameters. What should be the parameters that you need to take into consideration? Then, of course, variations, like my co-panelist YK already discussed. It's a primary stage that the parties have to undergo, and of course, flagging is very important at the relevant stage itself, because if you are not able to flag your issues with the employers or the main contractors or the subcontractors at the right time, you lose an opportunity to make yourself clear at that time itself. And of course, having undergone a particular case regarding this, I'll come to that at a later stage at the end, closing of my slides. It was a very good experience from my client's side of view, because my client was very precise in flagging their issues with the employer or the main contractor, because it was a tripartite agreement. Then you have to have your own compliance team, internal compliance team, which is a key, I believe, because having your documentation and record keeping is the best solution that any party in the project can have, because once your documents are up to the mark, you don't have to worry about whether the dispute is going to go your way or not your way, because you clearly know that if anything is in black and white, it's clear. So having your delivery receipts, of course, Incoterms is something which is also a very key element when you are having cross-border disputes. Having your Incoterms aligned with your contractual requirements, whether you are going, if you are, in case you are doing a supply of machinery or equipments, whether you are going to deliver them at the port, whether you're delivering them at the site, or whether you are asking the employer to collect it from your factory, because the last one is the most riskiest Incoterm that you can have, because as a supplier, you lose the right over the goods immediately. So that is something that I would not advise, of course. So having a CIF or something like that would be beneficial. Of course, and these Incoterms should be aligned with your payment terms. So whether you want payment at site, if you are delivering at the goods at the site, and whether the payment should be linked on the delivery. So that is something that you can think about. Then in your invoices, of course, whether there are any unpaid invoices, having a timely follow-up will definitely keep your disputes live. So that is something that many people ignore in construction disputes. Not having sufficient follow-up is something which I have faced in my own practice, because people consider that if you are not, having your follow-ups, routine follow-ups on your payments, then you lose the right to even claim that payment. So making timely follow-ups, regular correspondence with all the stakeholders in the project, including the employer, main contractor, is something that would be beneficial, because many times you have interpretation based disputes on correspondences itself, because those become trigger points. No, I have not communicated this, or whether even if you have communicated in a certain manner, whether that provides a clear intent of what exactly you wanted to say. So having a clear communication is very important during the tenure of your project. Then, of course, timely progress reports, minutes of meeting, which becomes sometimes a very critical evidence in disputes relating to retentions or disputes relating to technical matters, whether a particular task was supposed to be completed by the subcontractor or not. Recently reviewed a FIDIC contract under Silver Book. The project is based in Africa, and the employer had included a clause where my client was supposed to build a road to till the manufacturing plant. So I confirmed with my client whether this is something that you are willing to do. So my client said, I do not have the expertise of doing this. So then, of course, this is something which is key. Whether you have the expertise of doing that and whether you are able to flag certain issues, whether, okay, this is not my expertise, I am not going to do this. So you will need to appoint a local civil contractor. Of course, being a party in India and constructing a road in Africa is something which is not logical. And if it is not in the domain, you cannot have something, some clauses like this. So these are all the technical as well as the record keeping practices that you should follow. Then, of course, having an efficient dispute resolution process, internal negotiations sometimes do help. And of course, keeping a record of these negotiations will eventually help in your arbitrations. If at all the dispute escalates and goes to arbitrations. Mediations is, it's picking up in India actually. I recently spoke to someone who said that they in fact chose mediations over DB because it was a more fruitful and faster remedy than a DB in India in a domestic contract. Of course, I don't know about a cross-border situation where mediation has been taken over by DB or a DAB. So I think mediation can become a good tool if it is utilized in the right manner by the parties, or or if you appoint a correct mediator. It, I think, makes a lot of difference, because in mediations, the parties are less accountable. You don't have to produce evidences, documents, or anything. So in mediation, you are on the table discussing what exactly matters to you and why exactly there is a difference. So if it is utilized in a proper manner, I think mediation does help. So in construction arbitrations, of course, I have seen very rarely that an ARB med ARB is used, but I think it would play a vital role in maybe smaller disputes that you have a mediation. So I think VTA also has a similar structure like ARB med ARB. Of course, they don't have specific rules towards that like the SISC, because SISC has ARB med ARB separate rules itself, and you can have a separate clause in your arbitration in your contract for an ARB med ARB. Then, of course, time limits for notice of disputes. It's something very crucial. You need to follow the time limits which are been provided in your contract. And of course, you need to determine what could be a reasonable time to, for to have a notice issued, and what could be a reasonable time to get a response or whatever. So this is something which is very crucial again. Obligations, like I said, negotiation obligations to attempt settlement prior to arbitration is something which can play a crucial role in determining your disputes. Then the governing law of the contract, of course, is something which we need to have a good hold of, and determining the contract law as well as your jurisdiction when it's about cross-border disputes. Of course, selecting a proper jurisdiction is something which is key. Then we come to the next, of course, what are the types of payment, which my fellow co-panelists have already discussed or went over. Advance payments is something which, of course, is the basic. You can't really start work without advance payments. And how do you want the advance payments? Whether you want letter through the LCs, and what should be the Incoterms. whether it should be aligned with your contractual obligations. I already discussed that. And of course, interim payments, payments linked to key project stages, design, supply, erection. So whether you want payments linked to each element in your contract is something that you can determine at the time of drafting your contract. And how do you want those payments to be made? So retention money elements, of course, retention is a big issue in the construction disputes sector. I myself have dealt with 3 odd cases only on retention money. And of course, it was a little dirty because there were major disagreements between the parties over completion of the work as well as uh, design elements. And of course, whether there were variations, whether there were official variations or not, is something also which was under dispute. So the retention, of course, can be a big issue. In fact, in one of the cases I did, the main contractor connected the retention issue with the tax payment which the subcontractor was supposed to do, which was whether it was a valid point or not was under dispute. And it was a cross-border dispute between 2 parties, one from India, one from Bangladesh, and they were claiming that the Indian party was supposed to pay the local domestic taxes as well, and therefore they adjusted that retention money towards their liability of local taxes is something which was under dispute, and whether they were liable to do that. Then, of course, your final payments, which are connected to your completion certificates and address. It's important that you address all your complaints or take up points with your employer, sit with your employer, discuss with the main contractors whether there are any issues before the issue of your completion certificate. Of course, it's something like Mr. Kelvin also discussed that even after issuance of the certificates, the employers do not make the payments. So we need to take into consideration all the elements prior to filing your final payments, and internally have a discussion, of course, that okay, is this stage where are we at a stage where you are able to disburse the final payments? Then what are the compliances that internally matter for the stakeholders in the project, employer, contractor, and the subcontractor, of course. I would call the compliance team a pit crew, because in a F1 you have in your pit crew a person who's changing the tire, a person who's filling up the fuel, a person who is unbolting the cars, and you have different person for different tasks in a pit crew. I think a same example is valid in construction projects also. You should have a pit crew which is a mix and a blend of engineers, accountants, lawyers, and administrative staff which are experienced in the construction projects. And of course, all these persons should have an check on each other, because once these are tied up together, I think you will have a flawless compliance team. So it's very important to have a compliance team. And of course, it's very important to have all the stakeholders, all the professionals involved, which are key in construction projects. What should be the payment periods? So how the parties can utilize this time? Of course, these are internal practices, which are my own personal suggestions, which are coming out from my own practice experience. So how can you utilize? There is often a gap of 30 days, 45 days, or as per the FIDIC, 56 days when an invoice is raised and the payment is made. So in between, what should be the approach of the contractors to recover their payment? Basically, preempt if there are going to be any payment delays, whether you have completed the milestones, ensure a smooth discussion with your main contractor or employer, and of course, maintaining good ledgers for your retention and your invoices is key to keep your side clear. Like I previously again discussed, project funding, ensuring that the project is backed from start to end is something many people ignore a lot of times, because what happens is what I have seen in general practice is basically invoices. In many practices, invoices are marked with a certain amount of percentage of retention. So many times the employer has not even funded for the retention. It's just they have a mental thinking that, okay, 10% is something that we are going to pay at a later stage. So why bother about funding for that? So it's better that you ensure all of these elements, ensure that when an invoice is paid, the retention is the arrangement for retention is also secured on your part. Of course, there are many practices, like Mr. Kelvin also discussed earlier, of having performance bonds, of having a bank guarantee. Recently, I also came across a practice which has been started in New Zealand. They are having retention trusts. So whether, of course, these are practices which have been introduced in an X country, and whether these practice is implementable in your own country or in your own project is something that needs to be analyzed. But of course, you have alternatives to secure your retention money, which need to be uh, figured out at the time of entering into the contract itself. You can have an escrow, because this is something I suggest my clients. But of course, escrow also comes with its own dispute types. But if you have a certain level of trust with your employer or main contractor, I think escrow is something also that can work well. Of course, how do you resolve your non-payment disputes or issues? Mr. YK also, discussed certain elements where he triggered upon the compliances that needs to be taken care of when you have any non-payment issues. Focusing on your dispute mechanism over here, I think, is something which is key. Whether you want a multi-tiered dispute mechanism or not is something that you need to decide at the stage of drafting the contract itself. These I believe are the typical disputes. We go to the next stage. These probably are the typical disputes which come into the construction situation. Sometimes they are purely arithmetical or certificate driven, where there are wrong setups or deductions, or some mathematical errors or accounting proofs which are provided or not provided. Then valuation and variation, of course, and you have an entitlement based dispute, whether you have undergone a procedural compliance or not, whether you have sufficiently completed your tasks in the project. And of course, these are the interpretative disputes are something which take a very long time. So we have to be careful about all these elements which come into the disputes, and having a efficient case management system or a conference before at the start of the arbitration is something which is key, I believe, because once the parties have decided what is the type of dispute they want to submit to an arbitration, I think the arbitrator's tasks are easier, because the arbitrators are then able to give you a very precise mode of conduct of the arbitration. This is something which SISE also does a lot. I mean, having a detailed case conference or having a detailed procedural order one is very important. Like, you decide everything when you are going to file your claim, when you are going to provide your evidences, when you are going to have your oral hearings, is something which you can have charted down at the first meeting itself in an arbitration. And once the parties have decided what type of dispute they want to escalate in an arbitration, I think matters are much more easier for the arbitrators to decide. So certain arbitration processes which the arbitrators undergo is basically whether the primary thing is whether there is a clear and precise arbitration agreement between the parties. What are the procedural fairnesses that could be implemented by the arbitrators? So I have listed out a few, and of course VTA has implemented several of
I'm sorry. I apologize for my impoliteness, but as we are running a little tight on time, may I kindly ask Mr. Saga to wrap up your presentation,
Yep.
please?
Yes, I will do that. Yeah,
Sorry.
no problems. I can understand it's very difficult, to be glued to a screen for hours. So I'll just rush through the best practices, and I think I'm almost at the end of the slide itself. So what could be the best practices is clear contractual terms, regular communication between the parties, having undisputed minutes of meeting is something which is very crucial. Then in aligning your Incoterms with your contractual obligations, then of course this is the case which VTA had we had experienced at VTA. A subcontractor had filed for a claim under of around $1.2 million, which was, like I said, a retention claim. So what had happened is, in this case, it was a very typical ARB-med-ARB process which was followed by VTA, because the dispute was submitted as an arbitration. Eventually, the parties met, had a settlement, and then had a mediation, and then a consent award was issued by the VTA. I believe VTA issues an award within 7 days is something which I am very fascinated. I mean, it's very quick. This is something from my personal experience, a similar claim against a company in Bangladesh, which was a public sector company. Of course, there was a retention claim, then there was limitations. And like I discussed earlier, the set-offs were being claimed against the retention monies, which we won this. I mean, I was as a counsel in this arbitration. We won the arbitration. We secured the principal along with the interest. And of course, it's undergoing its fate in the Bangladesh courts right now for enforcements of the award. So yeah, I mean, key lessons is something you have to have your own internal compliances and determine what exactly is the best practice or the best solution for your contractual obligations you can have. So with that, I thank you for your attention, and I'm open for questions in the next session. Thank you so much.
Thank you, Mr. Saga, for providing an arbitrator perspective on payment dispute and best practice for contractor can adopt to avoid and resolve conflict. Now, toward part 2 of this webinar is panel discussion. Mr. Tung Chung will be our moderator together with panelists including Mr. Hùng Lê, Managing Partner at CNC Counsel, Mr. Kelvin R, Partner at CMS Singapore, Mr. Na Yun Kun, Director at FTI Consulting, and Mr. Saga Kunkhani, an VTA listed arbitrator. Thank you, and the stage is yours.
Thank you so much for all speakers to provide very useful experience and insight for our attendee. It's my honor to moderate this session 2 panel discussion. I already see on the screen that the audience also have some very interesting question, and I see that the speaker also answer, but I think it's useful to bring it up again to everyone can listen again. I think that the first question very interesting that under FedEx contract, the concept of pay now regulator is applied to resolve cash flow issue, requiring the party to comply with the entity determination, but the worrying about it's not on the case that the entity comply with the duty of impartiality when issuing determination. It means that the entity may be affected by the employer. And can the speaker share again how to arrest the case that the determination of the entity is not fair but affected by any factor or something? Kelvin, can you say again your idea?
Yeah, so this happens quite a lot. But then if one person says an engineer is impartial, Another person will say the engineer is not impartial. So
Right.
it's subjective.
Correct. Yeah.
And your view of the engineer's conduct is always based on what the engineer has not done for you,
Yes.
right? So if it's a clear case of fraud or influence that you have evidence for, then obviously we have to act on that and remove the engineer. I think there are provisions for that. But I think more common would be a situation where you're not sure, you're suspecting,
Yes.
because it's happening so often, but you can't put a finger there, right? So the only way really is to refer this to the DAAB, which is a truly independent board that sits under the FIDIC to adjudicate such issues. But unfortunately, I think a lot of practitioners adopting the FIDIC form always delete the DAB and DAAB mechanism, and that lends itself very unfortunately to arbitration, which is going to take a long time to deal with this issue. I don't know whether Hang you have another view on this.
Yeah, I think Mr. Hong have some additional idea on this one.
Yes, I do support the Kevin idea as I typing. It's actually we cannot say he have to be impartial all over the time. This is a person. So what the best of the FIDIC can do is to make him a kind of now the neutral. He's not acting on behalf of the employer anymore. So he has to make the determination. And of course, we will say the determination is not fair, is unreasonable. But because we have another kind of way to settle the issue between the parties to DAAB. So yeah, the best thing is to follow the process, considering engineer. The majority of the duty is to manage the contract, to administer the contract, to have the party with the project. So determination in some way might not be the main issue. So whenever we have an issue with him, we can move to the DAAB. If otherwise we go to arbitration, it should be a very big issue. Not because for the last time we do it workshop, the cost for arbitration is very expensive, but because it makes the party tension is very, very dangerous. The employer would not happy with the request for arbitration from the contractor. So the DAAB must be there in order to act with the determination, and then is follow the principle of pay now or claim later. So what we can consider is whether the engineer, they have the experience, they have the pipeline, or they are professional to manage the contract based on a very high standard. If we have a clear evidence, we can propose the employer to remove him and replace with another one. So I think that's it for the.
Yeah, thank you so much. Yeah,
Could I just add something to this?
sure.
I've come across a case in Singapore at least, where the contractor sued the engineer over undervaluation. But from an employer's point of view, that is also a tactic to influence the engineer. So while you might have that court case hanging over the engineer, I don't know how much mileage you actually obtain in trying to sue the engineer, but it has happened before.
Sure, thank you.
Yeah, we have a case like this, Kevin, because the engineer very ungenuinely making the determination without the substantiation from the employer, but he's trying to make the determination in favor of the employer without any justification. And we are very, which means the contractor were very unhappy. They first do with the kind of body from the government, making a warning notice over there because they are a foreign contractor. They are engineering, but they are a foreign contractor. So we made a kind of a warning letter to them, making a very serious issue that they are now breaching the law of Vietnam and so on and so forth. Otherwise, if you don't withdraw the determination, we will sue you for the torch or something. Yeah, that's it. Yeah.
Yeah, thank you. And Yang Kyun, can I ask for your additional idea. I'm aware that you work for a lot of projects in Vietnam as a contractor, so I think that you may face the same situation that you are the contractor and you had to comply with the unfair determination of the engineer.
Well, the engineer's impartiality is always an issue, but I always thought it's not something that the contractor can control because a contractor does not have a direct contract with the contract administrator or engineer or the architect. So I never really thought about suing the architect or the engineer, but something I did previously was this was under an SIA contract, and I reported the project architect to the SIA that he is conducting impartially and grossly negliging his duties. So, but it didn't really go anywhere apart from what Kelvin mentioned as a tactic to try to distract the architect.
Yeah, thank you so much. I think we have a second question. It's also an interesting question from Mr. Lop that what are your recommendations for the contractor at the tender stage to proactively mitigate the payment risk? I understand his idea that we do not need to wait until the contract negotiation. We need to prepare our plan in the very outset, very early in the tender stage. So could the speaker help to provide some recommendation or suggestion for the audience for this question?
So can I just jump in first?
Okay, sure.
So this is a tender stage, a tender exercise. So I assume that there's only so much that you can amend in the conditions of contract, right? So if there are no mechanisms under the contract, you can't add in additional amendments. So you'll be looking at upstream, downstream, and lateral type of risk transfers. So upstream, I think you want to do a due diligence on employer, whether they in fact have the means to pay, whether the project is bankable, whether they have sufficiently funded. Downstream, obviously, you pass down the same sort of issues to your subcontractors to make sure that if you are met with a payment risk, you pass it down to the subcontractor. Sometimes it can succeed, sometimes it may not, particularly when pay when paid is outlawed in certain jurisdictions. And of course, there's lateral transfers. Transfer these risks to insurers to the extent that you can buy insurance to cover these sort of contingencies. I think you should.
Thank you so much, Kelvin. Any other speaker want to add in?
Like to add to what Kelvin has said, I was about with the same thoughts, of course. Having a clear due diligence on your employer is very important. And of course, to secure your cash flows, this is the initial step, that having a clear due diligence of your financial of the financials of the employer is something that you need to have seen it prior to entering into the tender stage, and this will secure your cash flows.
Sure. Mr. Hong and Yang Kun, want to add something?
Yeah, I think what we have to do is to follow Mr. Saka's recommendation is to make the contract a kind of precise or in clear term. It means that, for example, we all know that from Jakun. See, he say about the nature of the process in order to get the payment. So we have to identify at the outset of the contract whether or not this is a kind of Vietnam standards, like to say, this is about including the quantity, quality, inspection, etc. So if we follow that way, of course, whatsoever we do, we have to do the same with Vietnamese style, that the payment would be the issue. So we have to make the contract quite clear and of course in the tender stage we can do with the kind of tender clarification questions on the employer financial arrangement. Of course, they might not have to be issued with the contractor for the evidence of what and how much money they have issued, but we can know that the majority of the finance is from the bank or from their own money or from the advance collection from the client or so on and so forth. So we can prepare ourselves. This is very risky, or it's possible to overcome or something. So it's mean the due diligence at the outset is very important. Yeah.
Yeah, thank you so much, Mr. Hong.
Would
Can we
like
can
to add another point if there's some time.
sure. Yes.
So, when you're at the tender stage, in fact, it's very important that as a contractor or subcontractor, you raise your queries about the tender at the right time, at the beginning itself. Because if you don't have clear understanding of the technicals involved in the project, you might be at a loss. Because I faced this in one of the arbitrations where my client had not raised the queries regarding technicalities involved in installation of a software on an oil rig for a local domestic petroleum company, whether it was a wireless device that they were looking at or whether they were looking at a wired device. So this is very critical. Raising your technical points at the tender stage is very important. And of course, this adds up as an evidence eventually if you are at a dispute in arbitration.
But very quickly, whilst you may raise those objections, but usually at the very end of the tender, you are asked to withdraw or your clarification.
Yes.
So
You
it's an
get a very
entire
standard,
agreement. So
you get a very standard reply. I understand that. But of course, it also shows the intent of the employer. You can then go on to arguing the intent of the employer.
Thank you so much for our speaker. Can I jump in the next question? I come back to Kenvin's slide that Kenvin mentioned a very interesting point about the retention money. I understand that you say that in Singapore project, the government do not require for retention money. It means that when the contractor finish the project, they can take on the money. So how we can balance between the government profit to make sure that if any defect during the DNP, the contractor need to comply with its obligation and balance with the favor payment term to attract more and more contractor.
Okay. So there are two securities under most construction contracts. One is retention monies, and the second is performance bond or security deposit. So whilst the Singapore government has removed the need for retaining monies, they have extended the validity of the performance bond beyond the DLP. So it rides all the way until final completion. And sometimes the value of the performance bond increases from 5 to 10 to sometimes 15. So in a way, they remove, but they put it back in again. So it sometimes is a matter of optics. So they're really saying that I'm putting all my eggs in the performance bond. I don't need retention monies from you. If I need anything, I'll just call the bond.
Sure.
Yeah.
Can I ask Mr. Saga and Yang Kyun about Korean and India perspective on this? Can the government side in your country usually keep retention money from the contractor to make
yes.
sure that he comply with the guarantee application?
Well, yes, very much so. I think it's usual to retain some money so that if the contractor does not comply with the defects rectification, then so that they can utilize that fund. If I could also add into this point of the person who asked the question, even like Kelvin said, even if performance bond were to extend over the project completion date, as a contractor who procures such bond, the premium changes. The premium during the construction stage is much higher. And after the completion, then for the defect notification period, usually the premium is less. And to the point of the retention bond replacing the retention, I think it is in most form of contract, it is not an automatic replacement. In most contracts, it will require the owner's agreement and approval. And I think that is a privilege to be had because obviously from the point of the owner, holding on to the retention money in cash is much easier than having to call a bond. So, and from my experience in trying to call a bond in Vietnam, contrary to what it says on the bond, immediately doesn't really happen immediately. So there you go. Thanks.
Yeah, thank you. Mr. Saga, you want to add something from Indian perspective?
No, I mean pretty much the same. I mean, in India also the practice of retention is pretty it's there. I mean, parties prefer having a retention money, but how you have it or what kind of elements you add to the retention is something that you can, of course, adjust in your contractual terms, depending on, of course, whom you are entering into contract. Because if it's like a PSU or something like that, they really don't care. So all they say is, no, you, if this is that, if you want to accept it or just leave it. But I think the practice which is followed in New Zealand is something which is picking up now, having a retention trust. But of course, like YK said, retention trust and escrow or retention bonds, where there is fluctuation, always a fluctuation in the amount which is deposited in the bond or the trust. The employer, always will have to keep a check whether the employer is maintaining that sufficient balance in that escrow account or not. So I think having steps over there also is something which you can practice. Maybe having a one-time payment into an escrow, and of course the employer deciding to release the retention money as per the tasks completed by the contract is something which can be and become an easier compliance, probably, instead of asking the employer to replenish the retention money during the project. Maybe you can secure your retention money at the beginning of the project so that you have certain kind of security.
Tony, can I have one on point on this?
Sure,
I
sure.
think typically because we are very famous for counsel for the contractor, but for this particular issue, retention money, I think there is one point we need to give for the employer, because too many contractors we act for, they claim that the retention money represent for the obligation to remedy the defect, but eventually that is not cover enough. The retention money is just a part of the obligation. It's just the money that the employer typically generally hold for remedy the defect. But if the defect incur more cost than the retention money, for example, some of the factory, because they have to suspend the whole factory for remedy, or they have to remove some of the equipment outside of the site, so it's caused the employer damage. It means that the employer has the entitlement to call not only for retention money bond, but of course for the performance security, so on and so forth. It means at that time, for example, from Singapore perspective, they don't hold a kind of a security, a surety. It does not mean that the employer don't have the recourse in order to secure their interest. So don't make it confused between two, and the dispute arise. The retention money is just part of the mechanism in order to secure the employer interest. Yeah.
Sure, yes. And from myself, I share very much with Mr. Yang Kun views that the bond we also say is a on-demand bond, but in Vietnam we already observed some case that when one party submit the demand to the bank say that we need to weigh something, or we need to some additional evidence to settle the money, because the bank absolutely understand the nature of the bond, but they do not want to do it very quickly because they want to secure the cash, they want to secure the capital, and they wait into the court or the arbitration provide some decision to follow. So that is the reason why some employers did not refer the bond, but they still refer the cash. But it's actually affect the cash flow of the contractor. Yeah.
I think just one last addition. I think one should also analyze from the contractual terms and conditions whether you have the power to suspend your work in case of non-payments of retention or non-payments towards your regular interim payments. So that is something which one should analyze at the contractual stage itself. Because in one of my cases, my client had suspended the work at the stage of installation.
Sure.
So he just pulled the plug That's about it. I have installed my machinery. I have erected the goods at your site. You can't run it.
So, thank you so much. For the audience, during the panel discussion, please feel free. If you have any question, please enter in the Q&A box so our panelists can address them. In the meantime, I would like to follow the next question that we promised to address in this webinar is about pay when pay clause from Singapore perspective, and understand that it's likely that the law prohibit the pay when pay clause. In Vietnam, we usually say the back-to-back payment clause. And understand that in Singapore, you do not allow to do that. But in some case, I would like to ask more about the perspective from India and Korea, and ask all the speaker what you think about the pay when pay clause. Is it a good idea, or it's not idea from your thoughts? Because from the role of the main contractor, it's maybe the good option for them to secure the cash. They only pay the subcontractor when they receive the payment from the employer. And if the law do not allow them to do so, it may affect the cash flow of the contractor. So what do you think about that? Can I start first with Yang Kyun?
Yes. Well, when I administer my contract, well, in Singapore, well, as you know, and the pay when paid provisions are illegal. The SOP Act stops that. But when managing my subcontractors, I tend to segregate the main contract from the subcontract. Sometimes the requirements may be able to be perfectly aligned. So in a way, it becomes like back to back. There could be some cases, but fundamentally, the terms of contract are different, and each contract is different. So I tend to look at it very separately. And I do not always follow getting paid and when paid, especially in Singapore. Then the subcontractors will take me to SOPA, the adjudication under the SOP. So what I do is I take it separate. And if under my subcontract agreement with my subcontractor, if they are entitled to payment, then I pay. But I may not have budget in my project. So in that case, I have to either get the budget, or as I briefly mentioned in my slides, there may be some temporary way for me to get the head office approval for this will eventually be a VO, but not at the moment. But I explain the reason, and I can get some temporary relief from the head office. So that way I try to deal with that independent and separately.
Thank you so much. Mr. Hong, continue. Yeah, Mr. Saga, can you share more about the Indian perspective?
I think the primary difference is where civil law and common law differences are there. I think in India, it's pretty similar to Singapore. In India, also pay when you are paid clauses are treated almost illegal but they are subject to judicial review, of course, because the Indian Supreme Court itself have observed in many cases that these clauses are invalid, because you are going towards frustration of a contract, or you're going and of course you can't really change the contractual terms without having a formal or official discussions or so. Pay when you are paid contract terms are actually treated as illegal in India as well. Not officially like Singapore, but they are not well looked upon in India as well. So, but internally, of course, many contractors follow this practice because they have a certain kind of trust with the other party. But of course, if it falls, it will fall very hard in India as well. Parties will not benefit from this kind of clauses in India.
Yeah, thank you. Mr. Hong,
just-
Sorry,
Sorry.
I have idea. Actually, from Vietnam perspective, we recently, just about a few days ago, we have a proposal to change the law of construction. But what I think is that they already introduced the DIAB or DB concept for the law, but for the payment first and then argue later principle, I think hasn't been substantially changed very much, because that principle must be considered to be, for the first thing is to simplify the payment process. In order that, like foreign contractor like Jun Kun, you will no longer consider about inspecting and then submitting the quality and then financial submission, etc. We have to simplify the payment process. It's just the cash flow for the contractor. We have to differentiate between the work done and then the quality, etc. So we cannot mixing the same. The second is that we don't have any clear concept for prohibition. That is a kind of prohibition the party from the main contractor to pass down on the application of the risk to the subcontractor. Actually, I myself, I work for a general contractor. I propose not to apply that to subcontractor. This is because not because of the benefits for the contractor, because they don't have the financial issue to the subcontractor, but it's very damaging approaching. The first thing for that is because they don't have the pressure for the finance, so they don't very much care about the claim against the employer. So they just follow the process. They don't make the very proactive against the employer, but then they pass down for the subcontractor, meaning that the management level of their key personnel for the general contractor don't have. This is the big issue for the general contractor. And the second issue is the subcontractor. They are the one who actually carry out the work. They have their own personnel, they have the equipment, they have to pay to the supplier. So if they don't have enough resources, they have the problem. They cannot become a bigger one. So the general contractor build on a very weak subcontractor. It's, from a long-term perspective, it will be a big issue for the general contractor. So I very much protect and propose not to apply the back-to-back payment principle. So I think from Vietnam, from next time, we have to introduce a kind of reason that payment upon page are here in Vietnam. Yeah.
Yeah, Kelvin, please go on.
No, I think it's the same point that Mr. Hung raised. So in Singapore, while the payment paid is illegal, it has become so successful that a lot of retention monies have been released prematurely, because a lot of main contractors are holding a lot of subcontractors' retention monies, whether it's due to them or not due to them. They'll just hold it because they have not received retention monies from the employer. So applying the pay when paid illegality, all these retention monies, once it's reached the end of that particular DLP of that particular subcontract, it has to be released. So
Yeah.
it's become quite a problem for main contractors who have not received final accounts and therefore have not received the retention monies under the head contract. They have to release all the retention monies to the subcontractors.
Thank you so much, Kelvin. Can I go further a little bit that in the Singapore law, you do not allow the pay when paid law as the default position of the law, but how the case that the party agree to waive that law, the party voluntary that, okay, I do not want to apply that law. I agree that pay when paid law will be applied our contract.
You can't. So you can't contract out of the act.
Or even party agrees can leave. Yeah, okay.
Status.
Yeah. Thank you so much. Yeah. Yeah, I jump to the next question about DB. I think it's also interesting topic that under the new draft of construction law of Vietnam as a law, the first time the Vietnamese law provides the DB mechanism for construction dispute, but in Vietnam we do not have a lot of DB case. So would like to ask the experience from the speaker. So if you consider DB as the dispute resolution, so what the parties should be prepared to use the DB as efficiency methods. Can I go first with Mr. Saga?
Yeah, I think it's a very important element in your project. I mean, having a DB is quite a good step that you can take. And of course, determining the rights and powers of the DAB or the DB is something which you can highlight in your contractual provisions itself. Like what types of dispute should the DAB or the DB adjudicate upon is something that you can list it out in your contract itself. So that's something which is a good practice, and ensuring enforceability of the decision of the DBs. Of course, eventually it's whether it's binding decision or not, it's eventually the parties have to decide. Like I said, respecting the procedures. If the parties tend to respect the procedures which they have documented in the contract, I don't think they will face as many, difficulties in executing the project as we see in our daily practices.
Yeah, thank you so much. Giang Kun, you can share more about the DB case you had in Vietnam, right? Yeah.
Well, yes, it seems that at least FTI is and was involved in many DAB cases, and it looks to be a popular way of resolving disputes. So when it is successful, like the case I shared very briefly, then I think it works well. But I think the users will have to consider subject to the terms in the contract that I understand the DAB decisions are not really final. And I think the parties can still take this further to arbitration. So I think the parties will have to be aware of that fact and see if it will be worth going this route or not. But of course, depending on the situation of the project itself. So yes, that's my view.
Yeah, thank you so much. Kevin and Mr. Hong, may you add something here?
So I think DB is a good dispute resolution mechanism, obviously. But we've seen DB deployed in various Southeast Asian countries. And the most successful one, I think, is Indonesia.
Correct.
We have seen it done in India. We've seen it done also in Vietnam, but of less success rate. And I was just researching on why this is the case. It seems that it has largely to do with the limitation period under your jurisdiction.
Correct.
So in Vietnam, your limitation period for a breach of contract claim is about 2 years.
Yeah.
Right.
And the only means of stopping the clock from continuing, it's really starting a suit in a Vietnamese court or starting an arbitration. The DAB process does not stop time. So if I'm the respondent of a DAB application, I would drag it up. I would drag it up past 2 years for one DB. And once the DB decision is made, I will say, well, this is just too bad. Limitation period has gone. We just have to live with the DB decision. You can't arbitrate me anymore. Different from Indonesia, where the limitation period is actually 30 years. So you can DB all the way to 30 years and not start a court action or start an arbitration action. It still
Yes.
works, right?
Yeah.
I'm
That
not
is
so
that
sure
is
about
very-
India. Is that 3 years in India?
Yeah. I think that is the very important issue from our law too, Kevin. As I said, we just propose the DAB as a mechanism for settle the dispute, but we don't stop the time limit. That is
Yeah.
a big issue. Yeah, the big issue.
Perhaps parties can agree to extend the limitation period, just to be fair.
Of course, but as you said, someone like you are the respondent. You will not say that.
I won't-
You just
I
wait at
won't
the
want
end of
to
the day. You say,
interest
so go ahead. Yeah. Okay.
Yeah, sure. So one big big recommendation when using DB in Vietnam, that please care about the statute of limitation. The DB is not stop the statute of limitation. Even the case that the party agree that the DB will stop the statute of limitation, the court may not accept that provision agreement. Yeah. So please care that do not allow the other party use DB to lose your right to start the case. Yeah. I think its time is not so much, so I will come up with the last question about the material change in circumstance. From our point of view, that some case recently that when the market is very unpredictable and the party may want to use the law about the hardship, or in Vietnamese we call it the material change in circumstance, to renegotiate the contract. How, for example, for the payment term or about the price to reflect the fluctuation of the market. So my question is, in your jurisdiction that the hardship clause is acceptable as a default position in the law? And if yes, so how the party need to prove that? Can I go first with Kevin? Okay.
So we don't call it material change in Singapore, we call it force majeure, which is, I think it's a Latin term, right? But force majeure only gives you time, it doesn't give you additional cost. So we've only ever seen the employers or the Singapore government ever changing the contract terms during the COVID period. And that was really extenuating circumstances that circumstances that's really outside the expectation of the parties. But other than that, if you're talking about fluctuations in material prices and all of that, there are limited fluctuation clauses in the contract that can be deployed, but beyond which there is very little scope for changing the contract terms. And I think that probably is right, because you don't want every contractor at every corner to turn around and say, I can't perform because the material prices have increased. There must be some visibility from the markets and the indices available to you to know that whether steel prices are going to rise in the next year or two. There must be some index to indicate otherwise. So I think contractors need to take responsibility for that.
Yeah, thank you so much. Yakyun, can you go further? Yeah.
Yes, I think it is more of a question for the lawyers in the room, but if I could share a case of some public projects here in Singapore, yes, as Kevin correctly pointed out, there's no change to the contract terms. So I think contractually and legally speaking, not many of the contractors would be entitled to any additional compensation during the COVID period. But as Kelvin will probably know that many of the contractors involved in the public projects, I think they are having some separate discussions with public bodies, and they are given some compensation for their losses. And I have experience of assisting some of my clients in those negotiations. And one particular tactic that I may share is that COVID or some other events may prevent the contractor from procuring something that they could have procured earlier, but because of the event, they had to procure at a much later stage. So even if that contract does not really have an escalation clause, then there were some cases where we successfully argued that had this not happened, and some of it could be neutral event like COVID or employer culpable events, then they could justify to some extent that they couldn't procure at the time, but had to procure later, which led to increases in prices. So that is one case. Yes.
Yeah, thank you so much. Mr. Saga, you want to add something?
Okay. Yeah, no, I think I echo the points which are made by YK and Kelvin. In India also, changing the terms of the contract is something which is unpermissible. The subject to judicial review, of course, whether that will amount to frustration of contract or not. Then during the COVID times, of course, there were cases that the parties had to establish that it was absolutely say after 3 months or 6 months, the courts decided that you can just extend the timelines of your contract depending on the requirements in the contract. Like if you are at the last stage or if you are at the middle stage of your contract, you can just extend the timelines. So this was, of course, in an extreme case of COVID, where there was very uncertain times. But in general practice, it's something which people don't agree with. I believe in Vietnam, you are allowed to make changes in the contract as per the civil code. I'm not pretty sure, but I think
Yes.
the difference lies in a civil law society and a common law country. So I think Singapore and India share pretty much similar practices.
Yes, yes, yes. You correct that in Vietnam, our civil law have a provision to allow the party to uh, propose to change the contract condition when the circumstance change in materially. But from my point of view, it is allowed to do that, but it's not easy to do that because the contractor need to prove a lot that they need to prove that if they continue the contract with the old term, is significantly damaged. And as I heard from some arbitrator, they require that the threshold is at 15%, at least 15% of the original contract price to prove that if I continue with the old term, so I lost 50% of the contract, so I cannot continue like that. So I need to propose to modify the contract term or modify the unit's price. So conclusion is it's easier.
Similar to
Yeah.
very similar to the doctrine of frustration, actually, because when you are applying doctrine of frustration, it has to undergo a judicial review. You cannot really whether
Correct.
you are able to completely not satisfy the terms of the contract is under review in doctrine of frustration. So I think,
Correct. Yes. Correct.
but it's more acceptable in the civil law country as regards to the common law country.
Yes. Correct. Absolutely. Yeah. Thank you so much. I think we're running out a little bit of time. So today Friday afternoon. So it's my obligation to release people to go home soon. So thank you so much for all speaker and all attendee for you joining and stay with us until the time. And on behalf of CNC Council and VTA, thank you so much again for with us today, and hope to see you soon in our another webinar in the upcoming time. Thank you so much. Our speaker, can we have a little bit time to raise our hand? Our team can take a photo. Yeah. Thank you so much. Yeah. And enjoy your weekend. Thank you so much. Thank you so much. Yeah.
Bye. Good day.
Thank you. Bye-bye.
Thank you, on speaker. Yeah.
Hope to see everyone in person soon.
Sure.
That's right.
Yeah. Sure. Yeah.
Great. Yeah.
Yes.